Thank you for joining us here today in celebrating the launch of much anticipated Case Laws of Mauritius, a compendium by Urmila Boolell. My name is Marie and I'm a director at Temple Publications, and I'm humbled to be your MC today. I'll just get started for the reason we're all here this afternoon. The compendium is indeed a labour of love by Urmila. It's a product that's proudly published by Temple Publications, which most of you may be familiar with as a conduit to LexisNexis libraries, Dallos, Juris/Lasher, now known as Lexis 360, and other cornerstone publications for the legal profession. In addition to these distribution activities, Temple Publications has launched its own print publishing activities with the Code Civil Mauritian in 2018. And of course, followed by the compendium itself in 2020. With a number of exciting print and online publications applicable to the Mauritian legal landscape in tow for 2021, the publishing of the compendium remains a fixed and fond memory on the highlight reel of Temple Publications. Whilst producing quality and content and publications is a standard we hold ourselves to at our core, we pride ourselves on partnerships with global publishers in order to fulfill a prophecy. In order to fulfill a prophecy of bringing global content to your doorstep, we have meticulously cultivated and maintain an exclusive online e-commerce experience via our dedicated e-shop, which you can find on our website. I will take a moment now to introduce you to our global partners, all available on our platform. Right, so the Case Law of Mauritius, a compendium, in its original form, is a brainchild born out of dedication to the profession, determination, and good old-fashioned hard work by Urmila. The first edition was a self-published 2-volume set in 1994 and featured case law dating back to 1861, which is the official date of the launch of law reporting in Mauritius. The now updated 5-volume, 7,700-page edition sees the initial version in its entirely rewritten form and updated with case law up to and including 2019.
A special word for Sir Hamid. I'm very happy to meet it. And for my mum and dad. Thank you very much for being here. Dear friends. The compendium was launched when it first came out in 1994, and to my mind, did not need to be launched anew for its second edition. However, when I saw the finished product, I realized that I would not be doing justice to the enormous difference between this second edition and its predecessor if I was merely to treat it as an updated version. The second version of the compendium is a new book in its own right. It has been heavily inspired by its predecessor, but it has an identity of its own. For the past 7 years, I have actually gone back on each and every judgment in the previous edition and reviewed the extracts of judgments and considered their relevance with fresher and more mature eyes. The end product is therefore a truly new creature. Let me therefore take the opportunity of today's launch to share the experience I have lived so intensely for the past few years of my life. First of all, I must say that I was driven by nothing else than personal passion and curiosity in writing both editions of a compendium. The time, effort, perseverance they took, as well as the accompanying emotional roller coaster, cannot be measured by any tangible yardstick. One cannot start listing the multiplicity of road bumps that have had to be tackled to reach the finishing line. Enthusiasm was met with discouragement, joy with fatigue, determination with self-doubt, resilience with frustration, and so on. The one thought that kept me going was that I did not want to live with the regret of not having fulfilled this contract with myself. For indeed, this was and has only been about pleasing myself. This book allowed me to travel back in time and encounter situations which we could not fathom in our own times. There was a case of La Paille in 1879, which decided the fate of her sisters Eleanor and Virginie La Paille, and the determination of their civil status as descendants of slaves. There was, of course, the case of Acha in 1909, which tackled the delicate issue of determining whether a contempt of court could occur if a witness of Asian origin refused to remove his headgear whilst removing his footwear as a sign of respect for the court. The depth of analysis into which Justice Thibault indulged before reaching the conclusion that a witness who stood in the witness box with shoes on but without socks was guilty of contempt is nothing short of flabbergasting by today's standards. And then there was a stark confrontation with literacy problems of a not too distant past. The following words of Chief Justice Niranjan in 1964, when considering the literacy requirements of candidates at the 1958 elections, make interesting reading. I quote, Messrs. Mounian and Barbie were examined and given ample opportunity to show their degree of proficiency to speak and to read the English language. Mr. Barbie failed lamentably. He could say a few words of colloquial broken English, but his language was incoherent and he could not express himself properly. On the whole, he can be described as being inarticulate in the English language. As regards Mr. Mounian, he has a smattering of colloquial English and can read passably, but is far from being fluent. Several graduated passages, all of them easy, selected from Hansard of the debates of the Legislative Council, were read to him, and he was asked to say what he understood or to give the substance in his own words, but he could not do so. 2 easy short passages were read to him at dictation speed, and even then he did not understand what they meant. He was requested to read a passage himself, and when asked to say what he understood, he confessed that he could not do so. I conclude that his knowledge of English is rudimentary, and his ability to speak the language far below the norm fixed by Section 23D of the Order in Council. End of quote. At times, I felt like a privileged bystander, witnessing the lives of judges themselves. In 1863, at a time when the Supreme Court was manned primarily by the Chief Justice and his first peonage judge, it was left to Senior Peonage Judge Bestel to decide a case brought before the court by his boss, the then sitting Chief Justice, Farquhar Shand, who claimed damages against the carrier P&O for the loss of his baggage on a sea journey. In 1932, a special case was brought up to the Supreme Court upon an appeal made to the Governor General by one P. Lalouette, acting on behalf of the then minor G. Lalouette. The matter concerned a decision of a rector of a royal college to allow one M. Kushni, who had not fulfilled the requisite residence qualifications, to be a candidate for the English scholarship. The decision of a rector had been endorsed by the Procureur General, and when the results were published, the said Kushni was awarded a single scholarship on the classic site, with G. Lalouette ranking second. This appeal to the Supreme Court, no doubt a precursor of our modern judicial review, allowed G. Lalouette to overturn the award for the reviewing scholarship to be granted to him on account of a wrong decision having been taken with regard to a failure of M. Kushni to meet the requisite residence criteria. The rest is truly history, as G. Lalouette was then able to undertake legal studies in the United Kingdom and went on to become one of our most eminent judges of the Supreme Court. Whilst going through some forgotten judgments, I was reminded of one of my own first cases before the Supreme Court. I was then barely 21 and undoubtedly the youngest member of the bar, and my opponent was the formidable André Raffet QC, then senior-most member of the bar, comfortably in his 80s. This singular irony did not pass unnoticed by the trial judge, Justice Annie, who indulgently commented as follows in his judgment. I quote, "The applicant's motion to be allowed to adduce fresh evidence is resisted, and I have had the privilege of listening to the very able arguments of Mr. André Raffet QC for the applicant and Ms. Benimander for the respondents." End of quote. The passage of time has been a great healer as regards human rights, social inequalities, and the enjoyment of fundamental rights. Our Constitution brought a gust of fresh air, and along with it a spate of pivotal judgments, leaving no doubt on the firm intention of a judiciary to be seen as the ultimate guardian of the constitutional rights and freedoms of all Mauritians. A number of judgments on the rights of illegitimate children, concubines, and women in general make, however, uneasy reading. The evolution of the law and the introduction of new laws have no doubt tampered this situation, but prejudices belong to their times, and judges living in those times were sadly not spared. Conversely, my journey through the years has also allowed me to reflect on how the wheel of time does not always yield change. When reading a case of Duré versus Gallimard Frère of 1868, one could be forgiven for mistaking the following words of Chief Justice Chan and Justice Bestel as being extracts of a modern judgment. I quote, "It is not unimportant that suitors should enter this court by the right door. If instead of a strict adherence to the rules of practice and to the forms traced out by the rules of court for the guidance of practitioners, the latter were at liberty to lay aside the forms given and to adopt others of their own framing, there would be an end to anything like certainty in the practice. Confusion would be an immediate result from such a departure from the rules of practice of this court, to the great prejudice of suitors and a great hindrance to a safe and speedy administration of justice." End of quote. I could not end this travel in time without commenting on the many times when in the middle of a judgment I burst in loud laughter, tickled with delight at the mastery of language of eminent judges. I can think of nothing more intellectually stimulating than the use of sheer wit, dry humor, and disarming quips to make a very serious point. The following extract of a judgment of Chief Justice Rowe and Justice Espitalier-Noël in 1982 is one such nugget. I quote, "There is one aspect of this case which gives us cause for concern. The clerk who prepared the certified copy of a record seems to have been bent on packing into it the largest numbers of howlers possible. Thus, he makes the magistrate A. wonder whether certain parties should have been feigned as defendants, feigned spelled F-E-I-N-E-D, as defendants. B. Speculate 3 times as to the position where the tenant, I quote, leaves no widow or has a woman, end of quote. And C. Remark, open quote, I can do no better than him to the English cases, end of quote. After thus warming up, the clerk proceeds to libel Mauritian households by referring to, I quote, family vexes, and to throw a sinister light on plaintiffs by renaming them eliminants. Then, after alluding to a game called social moves, and to the de pure relationships generated thereby, he out-Joyces James Joyce by coining the ominous word pervisponderance, which seems to threaten that might should be right. Next, after 2 tantalizing allusions to a split character described as an enemy mistress, he crowns it all with an innuendo to end all innuendos. He refers to us, unfortunate judges, as their hardships, a title we certainly deserve, but which out of courtesy has not yet been popularly used in our courts. End of quote. You will have gathered by now that writing the compendium has been one of the greatest pleasures of my life. I now humbly pass it down to the whole profession for their turn to share that joy. I do not presume to take all the credit for honoring this contract with myself. I have now reached the point where I must do justice to all those who have played a role in making today happen. My parents have both eagerly been waiting for the book to be completed. My daughters, Vandana and Aditi, and my son Nikhil and his wife Anji have all been ardent supporters of this project. They have been instrumental in pulling me through the hardest part of this expedition, especially the last grueling months. Nikhil has put in long hours at the end of a project to finalize the typesetting and proofreading of the 5 volumes. And my best friend Ajit has been my silent rock. He never questioned my ability to complete this feat. I must also salute the tireless efforts of Esmery, Director of Temple Publications, in her dealings with the typesetters in India and the printers in South Africa. Finally, I must thank all of you for finding time to join in my moment of pride. My deepest appreciation must, however, go to the Chief Justice, who I have known as a friend for the whole of my 35 years at the bar. Thank you, my Lord, for your spontaneous support for the Compendium and your presence today.
Mrs. Urmila Boolell requires no introduction, except that she is married to her best friend, Satyajit Boolell. Her latest achievement, which brings us here today, is the new edition of her Compendium. Impressive in these 5 volumes. But this is not her first publication. As already pointed out, in 1994, Mrs. Boolell produced a first compendium of the case law of Mauritius. Her second publication in 1997 was a book entitled Company Law of Mauritius, which provided a comprehensive review of various aspects of company legislation in Mauritius. This second edition of the Compendium is much more than an update of the 1994 edition. It covers a much broader array of subjects, and the case law included in the new edition spans the whole period from 1861 to December 2019. There is no doubt that such a comprehensive compendium, with its rational and well-ordered presentation, will provide law practitioners with an effective tool to have a quick and ready access to our case law. I hardly need to point out that an in-depth study of our case law is essential in order to have a proper understanding of the interpretation and application of our laws. One of the main difficulties which the practice of law entails in Mauritius is the scarcity of legal textbooks, publications, and materials. The practice of law in our country is indeed a daunting and challenging task, in particular for our young lawyers, for several reasons. First, we are confronted with a heavy load of legislation. The Mauritian legislator has had at all times a propensity to come up with new legislation as the panacea for any of the serious problems which might arise with which we may be confronted. In his foreword to the new Mauritius Digest, Sir Maurice wrote, as far back as in 1999, with reference to what he describes as the cancerous proliferation of law, I quote, "One would feel intimate pity for the young lawyer who has to journey without maps through the uncharted jungle of our legislation, if we were not bound to reserve even greater compassion for the magistrate called upon to apply laws which are often harder to locate than to interpret." End quote. I would venture to add that Sir Maurice's observation would apply with equal, if not greater force today, as we are now confronted with an additional mass of legislation in respect of many new and complex areas of the law. Statutory laws, however, would remain sterile unless lawyers and judges pour life into them and infuse them with the vigor and strength needed for them to become meaningful in practice and for them to achieve as a living reality the objectives for which they have been intended. Portalis, who was one of the drafters of the Code Napoleon, recognized that it is impossible for any enactment to cover all the complexities of a living society. It only lays down, he says, general principles, and it is left to the courts to apply it as required by the context and circumstances of each case. As Portalis puts it, I quote, "The judges are the depositaries of the laws, the living oracles who must decide in all cases of doubt." End quote. Secondly, our task as a law practitioner in Mauritius is also made more difficult by the complexities inherent to our hybrid system of law. By virtue of the Treaty of Capitulation of 1810, and as later confirmed by the Treaty of Paris of 1814, the inhabitants of Mauritius continued to preserve their laws and customs following the taking over of Mauritius by the British colonial powers. Although the French codes have continued to remain in force, and Mauritius did not turn into a common law jurisdiction, the legislation in Mauritius has evolved in such a manner as to provide us with a legal hybrid system which is altogether unique. There were substantial changes brought by the British colonial powers, namely to the structure of the judicial system and our adjectival laws. The criminal procedure and the rules of practice became almost exclusively of English inspiration and subject to local enactments. Additionally, a large number of other enactments, borrowed essentially from English law, were also introduced during the English colonial period. After independence, and with the advent of our written constitution, the legislators of sovereign Mauritius have continued to enact laws in line with both the civil and common law traditions inherited from the two successive colonial powers, but the legislators have also drawn inspiration from several other jurisdictions. This has led to the development of a distinct corpus of Mauritian law, which, as was highlighted by Chief Justice Lala in the report of the Committee on the Review of Legal Studies in Mauritius, published in the Journal of the University of Mauritius at page 162, I quote, "In spite of its origins, Mauritian law ceased over the years to be partly English and partly French, but has developed into a significant body of law with a philosophy, doctrine, and jurisprudence of its own." End quote. Our judges, therefore, have had to grapple over the past 2 centuries with the tension created by the interaction of the civil and common law systems in a bid to deal with the inevitable confusion and difficulties which are likely to arise from the coupling of a rigid continental system of codified laws, logically and rationally structured, with an English component which is often the outcome of a different trend of philosophical thought produced by an elastic and flexible case law. Our case law, however, is replete with the creative interpretation adopted by the Supreme Court in order to come up with solutions where the law is at a junction between principles derived from French law meeting with principles derived from English law. Our law of defamation is a good example of such a hybrid interaction, which now in addition brings into play the provisions of our Constitution dealing with freedom of expression. Our case law has established that defenses to an action of for defamation, as they exist under English law, may be raised in an action which is brought as a délit or quasi-délit under Article 1382 of the Code Napoleon. I hardly need to point out the increased importance in such a context of the need for an accurate reporting of the considerable body of case law which form part of our laws. This is vital in order to understand how the law has been interpreted and applied over the years, and in what spirit the courts would administer justice in given situations. Judges and law practitioners would only be equipped to meet the challenges which the contemporary practice of law in Mauritius represents, and be able to bring their significant contribution to the development and enrichment of our jurisprudence if they are fully acquainted with the past and existing case law. The dissemination and easy availability of judgments is also important in order to bring home to the public at large the fair and transparent manner in which justice is administered. As was observed by Sir Ramparsad Niranjan in his foreword to the 1961 centenary edition of the Mauritius Reports, I quote, What ultimately secures justice and faith in its administration is perhaps not so much the substantive law invoked, but the mode in which it is applied and the procedure for determining rights and wrongs. End quote. To come back to what I pointed out earlier at the outset, the practice of law in Mauritius is not easy for a number of reasons. One, as law practitioners, we are confronted with a heavy load of legislation, a good part of which has not always been fully explored and interpreted. Two, we are also confronted with the difficulties inherent to a hybrid and mixed system of laws. Three, we do not have comprehensive textbooks, nor has there been any structured and comprehensive development of a doctrine of our own. Reliance on French doctrine is not always appropriate and may be risky, since it is often based on different legislation in France, which is not the same as in Mauritius. Publications of legal research and materials are rare and scarce. We are bound, therefore, in such a situation, in the absence of legal textbooks and a doctrine of our own, to rely on judgments of the Supreme Court and the Judicial Committee of the Privy Council as our only source of reference. Selected judgments are reported in the yearly Mauritius reports, and with the advent of Internet, it is possible to access the website of the Supreme Court for any judgment which may be of interest. But this is where this new compendium assumes its full significance as a vital tool for research. The manner in which it is structured provides an attractive backdrop to any of the subject which has been categorized therein, and it covers practically all the subjects with which we are more often concerned in practice. The way in which the judgments have been compiled and classified would provide the user with easy and quick access to the targeted information. There is a table of contents for each of the 5 volumes, which provides an overview of the contents of the 25 chapters. The table of contents provides a user-friendly guide to not only the chapters, but also the subheadings and subparts included under each chapter. There is also in each volume an alphabetical index of cases, and all cases within a subheading are listed in chronological order. The extracts from each judgment are meant to facilitate the user to access directly the required information without being submerged by a mass of cases and all the detailed information which these cases would contain. This is, no doubt, the result of an arduous and meticulous exercise in the course of which only those extracts which reflect the essence of the judgment have been retained after the judgment has been stripped of all its less important details. The compilation of the judgments in the compendium, therefore, has the singular feature of providing an instant overview of the legal principles laid down in our case law. It stands out as a user-friendly source of reference, which is very convenient for a rapid search and identification of all those cases which may be of interest to the law practitioner. But a word of caution, however. There's no doubt that the compendium would be very useful to serve as a concise guide and as a roadmap to more extensive study and research. But it might be necessary, in some instances, to resort to an in-depth study of the cases in full, in order not to miss out on any of the nuance or subtleties reflected in the legal reasoning and analysis of each particular judgment. No doubt mindful of the fact that the new compendium consists of the case law spanning the whole period from 1861 to 2019, Mrs. Boolell dedicates her work, I quote, "to all judges of the Supreme Court, past, present, and future, without whose judgments we would have no tradition of law reporting for posterity," end quote. Such a dedication is no doubt justified, but requires, in my view, two important qualifications. Firstly, the judges have at all times benefited from the invaluable contribution of an industrious and learned bar. A good judgment, more often than not, springs from good submissions. Secondly, the magnitude and quality of the work carried out by Mrs. Boolell cannot be underscored. The Compendium is not a mere compilation of judgments, but has required a huge input for selecting the appropriate cases and the extracts which reflect the essence of the judgments and their legal reasoning. We need to express our deep appreciation and gratitude to Mrs. Boolell for the admirable work which she has produced despite her heavy professional commitments. I'm sure that the new compendium will be of great assistance to our law practitioners and all other persons involved in the practice, teaching, research, or study of the law. Finally, we hope that Mrs. Boolell sets to task with renewed vigor and her characteristic enthusiasm to come up with another seminal work in 26 years' time or less. Even if she doesn't do so, however, she is entitled to be proud of her legacy to future generations.
Esteemed guests, for those of you who do not know, since I joined practice now nearly 5 years ago, Urmila has been wearing two caps. The first cap she wears is unconditional and one which only a mother can wear. The second cap is crafty and endearing at the same time. It is the one she wears as a ruthless woman's silk, tirelessly and against all odds, heading the law practice I belong to. For many of you who have family in the profession, you will understand what I mean when I say that both caps hold the ingredients to what can be an explosive combination. In September of last year, I vividly remember receiving a telephone call from Urmila. I was turning 30 then, and I wholeheartedly expected the conversation to be about the plans she had for my birthday celebrations. In my mind, maybe I was in for a stroke of luck. Maybe she was, after all, throwing a wild birthday party. Or maybe she had bought me a pet pony. Well, obviously the object of the call had no remote reference to the word party. You have gathered she was wearing the second cap. Instead, she asked if I was willing to proofread the compendium. I do think she certainly slid at the end of that conversation the harrowing word deadline, and something along the lines of a one-off slot being booked with the printers. It turned out I had a little more than a month to do so. Soon after, I was on the receiving end of what is now 5 volumes worth of case law, spanning from before our independence to 2019. I can confide with you that never had I ever burnt the midnight oil so repetitively. Fortunately, whilst this bore no effect on my still tender marriage, it did, on the other hand, have an effect on my laptop, which mysteriously crashed sometime after I completed the assignment. Now, with hindsight, I accept I was extremely privileged to be entrusted with what was effectively a lifetime of work. I soon understood why Urmila had been sat on a chair, glued behind her computer screen for months. So much so that she had blended in the decor of her home office and effectively become a chattel. So much so that the once tamed dogs at our family home proclaimed self-determination in the television room under my father's helpless watch. I can confidently say that my individual contribution was minuscule in the greater scheme of what Urmila had so relentlessly and brilliantly created. All that remains for me to do now is extend, on behalf of Urmila and the team at Temple Court, our gratitude and deep appreciation in no particular order as follows. His Lordship, the Chief Justice, for accepting to be the chief guest at today's event and recognizing the greater importance of what today represents. To what our Constitution refers to as the judicature, the body of judges of today, and in no lesser regard the judges of yesterday, who have delivered judicial pronouncements that form the very substratum of our common law. These pronouncements have opened the space for academic and critical appreciation, without which a democratic society cannot function. To the legal profession in all of its quarters, it follows that there would be no evolution of a common law if not for the advocates and lawyers who have boldly driven moot points in law before our courts and at appellate stage before the Privy Council, whether successfully or not. To each and every one of you for being present, for having taken time off your schedules. The event was organized at short notice, and without interest in such events by the legal profession as a whole, I fear to our detriment we may be preventing ourselves from adequately sharing our intellectual appreciation of Mauritian law. We also wish to thank the Mauritius Bar Association for making its seat available, and to the team from Temple Publications who have worked hard to put up today's event. You will recognize yourselves. Three anchors to Urmila's life: Esri, Willem, and Ravi. It is hard to describe what these persons have brought in helping Urmila keep afloat all of her professional activities. On a personal note, to the persons who have supported Urmila for thick and thin and have believed in the cause she undertook well before she even saw the end of the tunnel, I think of the family, especially my father, who himself was battling his own demons at the time the book was nearing its final stages, my sisters who are both present, and as we affectionately call them, my Nana and Nani who are present here today. Finally, whilst today's event is much bigger than Urmila or Temple Publication, it remains about publications in Mauritian law and the important legacy such publications hold. On this note, congratulations Urmila on this tremendous accomplishment. Thank you for your attention.